A good batsman bats on all pitches because when you bat on all pitches, you know when the ball is going to come slow, when when the pitch is spinning. So you don't get out. You become Rahul Dravid, as the wall, and you keep balling balls to the wall. The wall is standing. Yes.
Hello and welcome to Verdictum. I am Ananya Singh and today we are going to elaborate on the whys and hows of the SC AoR exam. And for that, we have a special guest with us today. Please welcome Advocate Namit Saxena. Mr. Saxena is an advocate on record at the Supreme Court of India. He obtained All India Rank 2 in the AoR exam in 2020. He has worked with Justice Kurian Joseph as a law clerk, after which he was offered a position at the chambers of the then Solicitor General of India, Mr. Ranjit Kumar. He has revised and co-authored 6 legal classics, including Code of Criminal Procedure of Ratanlal Dheerajlal, Civil Procedure Code of Mullah and Pollock, and Mullah's Specific Relief Act. He has also assisted Justices Chalmeshwar and D.S. Naidu in revising the MP Jain's constitutional law. Mr. Saxena, welcome to Verdictum.
Thank you.
I will start my line of questioning with what is the AoR? Please talk us through its history.
See, so as per the Supreme Court rules, the earlier 1966 rules and the current 2013 rules, only an advocate on record, in short, we call it an AOR, can lodge a wakalatnama in the Supreme Court. So all filings, except if somebody is a petitioner in person, all filings are to be done through an AOR in the Supreme Court. And for this, you have to, pass an exam which the Supreme Court itself conducts, after a certain amount of, years you're put in practice. And after 1 year, mandatory training under an AO who has had 10 years of experience as an advocate on record. So that is when you can write the exam. This exam, as per the rules, is to be conducted twice a year, but in practice, it is conducted once a year. There are around 3,300 odd AORs, out of which around 800, 900 would be regular practice in the Supreme Court. So this is what primarily the AOR, advocate on record is.
Okay, and when did it begin?
So I think it began, see the history of Supreme Court goes, you have to trace way back to federal court. Federal court was a declaratory court, and the Supreme Court came into existence once the constitution was adopted. And then, the system of AOR was there, but, as per the Supreme Court rules, which came in 1966, this was given a concrete form. Because prior to this, we had a 1926 law,
Right.
Which used to govern pleaders and advocates. And the Advocates Act also came in 1961. It is when the system was devised. So, interestingly, the Advocates Act only talks about two types of advocates: senior advocates and advocates. But for Supreme Court practitioners, this is this third category, which came under the Supreme Court rules in 1966, which is advocate on record. So, only an advocate on record can lodge a wakalatnama. Why this was done is because Supreme Court being the highest court of the country, so that nobody can make a statement and go. For example, if somebody comes from southern part of India, makes a statement and goes back, so you can't actually trace that individual or that practitioner as to whether that statement may be incorrect, or also many reasons. So that advocate on record is responsible for everything, because he has to sign the petition, he has to give a certificate in a specially petition or a writ petition, or a review petition as well. Then so he's responsible of everything. So the cause list also gives names of only advocate on records, so that you can identify which matter is listed through an advocate on record. That is how the system functions.
So other advocates can also work with a advocate on record at the Supreme Court.
Yes, so other advocates can appear. There is no restriction. Even somebody with a 1 day practice, 1 day enrollment, can also appear in the Supreme Court. There is no restriction, but the filing is to be done through an advocate on record only.
Okay. So what would you say are the benefits of being an advocate on record?
See, one, as I said, that you can lodge wakalatnamas exclusively in the Supreme Court. So you're, in that sense, you have a different class amongst a bigger class, that you can lodge wakalatnamas. So all service, etc. For example, if you are you're an advocate on record is appearing for the petitioner, the respondent wishes to file something, he has to serve whatever he wants to file on that particular petitioner's AOR. or if somebody wants to, file an impediment or an intervention application, that also has to be served on the advocate on records who are there. This is so that ways, whatever pleadings are there, the pleadings also pass through the AORs. If somebody wants to adjourn the matter by circulating a letter, that has to be served upon the AOR. The AOR can very well object to circulation of that letter also. So, if you want to practice primarily in the Supreme Court, apart from, wherever you practice, if you want to practice in the Supreme Court, being an advocate on record is an added advantage, because you can, you don't have to look for an advocate on record to lodge wakalatnama for you. You can very well sign and lodge wakalatnama along with your petition.
Right. As you said that there is an exam that is conducted to become an AOR. So who sets the exam and who evaluates the paper?
See, this exam is conducted by the Supreme Court itself. And this exam, see who sets the paper. So, they designate senior advocates every year, who change, as per, that years, depending upon a lot of circumstances, their health, etc. So they designate senior advocates to set the paper. That paper, of course, goes through this advocate on record examination committee, which the Supreme Court has. And they can also very well, set the paper, amend the paper, alter the paper, whatever they want. And then there are these lectures which are conducted by, by the Supreme Court through senior advocates, designated senior advocates. So this is not a declared practice, but an undeclared practice, of all the aspirants of advocate on record examination, that whosoever is, taking that lecture is eventually going to check the paper also, check the answer sheet also. So this is an undeclared practice. I don't know if that is true or not, but that is what, people generally follow at the bar. So this examination is divided into four papers: leading cases, practice and procedure, drafting, and professional ethics. So all these papers are subjective in nature. They are conducted for the duration of each of these papers is 3 hours, and all these papers are of 100 marks each. So the threshold to clear the exam is that out of this 400 into 400 marks, you have to have a minimum of 240 marks. That is 60%. There's the passing cutoff. And individual papers, you have to get 50 marks at least. So individual papers, 50 marks, and in total, you have to get more than 240, 60%. So then you pass the exam. There is no vacancies which are notified. There is no upper limit or lower limit of accepting the number of AORs in a particular year. Whosoever passes, passes. And these four papers they have different, in a sense, formats and different, because in drafting paper, generally what they give is they give you four questions, to be read and to be drafted, whatever synopsis of the complete SLP or a counter affidavit or a transfer petition or a review curative, whatever they're asking you to draft. So so they have different mechanisms of asking questions in these four papers.
Wow. Okay. So what do you think is the strategy to prepare for this exam?
Strategy, see, I think, for practice, see, all these four papers have different strategies. For example, for the paper on practice and procedure of the Supreme Court, you have to be very thorough with the Supreme Court rules, 2013, along with, a few very relevant provisions of the Constitution and few very relevant provisions of different statute books from which civil appeals or criminal appeals come to the Supreme Court. So you have to be very thorough with the rules. You have to be very thorough with the jurisdiction which the court exercises from different statute books, and you have to be again very thorough with provisions of the Constitution. And there are few provisions of CPC and CRPC also. For example, you get transfer petitions under 25 CPC, and you get criminal transfer petitions under Section 406 CRPC. So you have to be very thorough with the provisions and how this jurisdiction is exercised. So, for example, when you see Article 131 is original jurisdiction of the Supreme Court. So it's in form of a suit, in form of a civil suit. So there you don't plead as petitioner or respondent. You have to plead as plaintiff and defendant. So somebody plaints and somebody defends. So, and then there's this entire procedure under the rules which is to be followed, and who can file, etc. A lot of things are there. So for different exams, it's different. For example, now for drafting paper, you have to keep in mind that you have to be extremely neat. You have to keep, you have to think like you're putting a petition before a court. So you have to keep borders, you have to keep, that format which is there. You can't, play around with the format. You can't, experiment and have your own format and, do it. There's a fixed format for everything. You have to, otherwise that petition would be defective in nature. So for drafting paper, they generally give 4 questions of 25 marks each, and where you have to be, you have to read also, and you have to write that particular petition also by hand. So what we generally do in practice is, for example, if somebody has to draft an SLP, what they'll do is they'll pick a format of a criminal SLP, for example, and they'll just change the cost title, etc. But in exam, you'll have to actually start writing in the Supreme Court of India under Article 136 of the Constitution. So the trick to clear drafting paper is that you have to, do a lot of writing also. Because when it comes to writing in the Supreme Court of India, because we are not used to it, we are a keyboard generation. So, but these exams, because they're subjective in nature, so you have to write everything by hand. So you have to practice a lot to write as well. For leading cases, see, when I wrote the exam, there was a list of 41 odd cases. Now they've revised it to 64 odd cases, including a judgment as voluminous as Keshwananda Bharti, which is, one SCR in itself. So see that, but interestingly, leading cases is an open book exam. So you get this head notes of SCR. So, like, for example, now we have ESCRs also available. So you should read that judgment about especially the head notes from SCR, because that is what you'll get in the paper, during the paper. So you have to be very thorough. So you don't have to mug up, anything, because you'll get those head notes. But you have to be very thorough with the follow-up of that particular case. Like, for example, there's this and not only follow-up, but the background of the case as well. Like, for example, we have this leading case called Selvi versus State of Karnataka. Now, why Selvi is important is because, in the background, if we see, so in 2001, there was this big, terrorist attack which happened in the US. And then after that, there was this 26/11 in India. So there was a series of terrorist activities across the globe, more so in India also. So there was this Dr. Narco who used to be very famous, and Dr. Narco devised this something which was known as a truth serum. So she used to inject truth serum in terrorist accused, and she used to extract confessions from them. So, and she had her laboratory in Karnataka. So Selvi was one such accused who said, "Ki, what is this? You can't, this is testimonial compulsion, and this is against the principle of Article 20, Clause 3, which is self-incrimination. You can't force me to, have a confession extracted from me." So this matter came out to the Supreme Court, and the Supreme Court said that you can't, do it involuntarily. Voluntarily you can do or take court's permission, but as an investigating agency, you can't force someone that will extract your confession. This is directly violated of Article 20, Clause 3. Now, this is the background in which 20 clause 3 is important. Now, in the aftermath, you'll when you asked a question on Selvi, you'll also have to tell about what has happened in case Puttaswamy. That is privacy. So privacy is both physical and mental. So this would fall under, subject to, different things. It will fall under different aspects. So as a follow-up, you have to mention Puttaswamy. 3 judge, 5 judge, 7 judge. 5 judge, not 7 judge, 3 judge and 5 judge. 5 judge, there are 2 rather. So as to how they have dealt with privacy. And then, the 7 judges, which is considered MP Sharma, etc. So this is how, background, you have to give a brief background and, what has happened as a follow-up of that particular case, particularly reservation cases also. And then you have to check whether a reference is pending. For example, we have this case of Bangalore water supply, where you give the definition of industry. So that has been referred to a 9-judge bench, which is pending. So in Jabi Singh versus State of Uttar Pradesh. So you have to write about that also. So you have to be very aware of what is, happening on those particular leading cases also. Now, Keshwananda Bharti, for example, you should know who were the judges. What was the majority opinion, what was the minority opinion, what was Justice Khanna's opinion, which tilted, the final version towards, doctrine of basic structure. So, and what is basic structure? What all is included in basic structure? So for leading cases, you have to work the hardest, is what I would say. For professional ethics, you have to be very thorough with the Advocates Act, the Bar Council of India rules, the Supreme Court rules, of course. Then there are a few cases on right to lien, then duty towards colleagues, duty towards opposition, duty towards court, duty towards client, etc. So all these are there. So this is how, so the strategy for all four papers is different. So a strategy to prepare can be that you start with practice and procedure, because that way you cover two examinations, rather three examinations. One, practice and procedure; second, drafting, because you go through the formats; and third, professional ethics, because you have to anyhow reread the rules for professional ethics also. So this can be one of the strategies.
Okay, and does it also help when you are picking optional subjects in your law school while undergraduating? Does it also help in the exam?
No, no, I don't think so. Because, when you are in your law school, you may want to, do everything under the sun and the moon, because you have that, that streak to learn a lot, to do more.
Hmm.
But but this examination is conducted 5 years, at least 5 years after you'll graduate. So a lot of water, flows under the bridge, till then. You may opt to practice in the Supreme Court. You may not opt to practice in the Supreme Court. You may not opt to practice in Delhi at all.
Right.
You may go back to your hometown, or wherever high court you want to practice in, or district courts also. So it depends. So law school would be too early to prepare for an exam like advocate on record.
Okay. And
Mm.
when you talk about taking this exam, what are the common mistakes that the candidates you think make while taking the exam?
See, I'll tell you the most common mistake people do. See, when you plan to write the advocate on record exam, for example, if somebody is planning to write, or somebody was planning to write the exam in 2023, see, what has happened is that, earlier it used to happen in June.
Hmm.
After corona, it had started happening in December, because of the lockdowns, etc. So you have to give, now before you want to write the exam, you have to take something which is known as a commencement certificate from an advocate on record who has had an experience of 10 years as an advocate on record. So you give a commencement certificate at least 1 year prior to the date of notification of the next exam, so that you are eligible to write the next exam. After 1 year, you have to give a completion certificate
Okay.
from that AOR only. So the most common mistake is that people, don't take commencement certificates on time. Then they don't deposit the completion certificates on time, and
Okay.
they don't fill the form on time. This is the most common mistake I've seen. So they waste 1 entire year, because then they'll have to wait for 1 year and write the exam thereafter.
Because
So
of
this
what
is one of the
legal
most
letter.
common mistakes. Yes. So you have to be very cautious about when you, when you deposit the commencement form in the registry, in the Supreme Court registry. That is the most common mistake.
Okay, so you can avoid this mistake by just taking the certificate on time, submitting it on time.
Yes, yes, awareness.
And personally, why did you take the exam?
See, because I was a law clerk to Justice Korean Joseph, so I was lucky enough to, one, have him as mentor, exceptional human being. Second, I was lucky to directly come to the Supreme Court, and see, the highest court of the country. And there's only one Supreme Court. So I was very lucky that way. So I thought that, why not? So I decided that I'll practice in the Supreme Court. And then I thought, and then I, rather more than thought, I came to know that, to establish yourself in the Supreme Court, you should become an advocate on record. So that is why I wrote the exam. And I was very blessed to be accepted in the chambers of Mr. Ranjit Kumar, also, who was the Solicitor General then. So there also my exposure was in the Supreme Court. And thereafter, I briefly worked with Mr. A.K. Prasad as well, who is an advocate on record. So again, Supreme Court. So that is why perhaps what may have weighed, in favor of writing the exam. Because if you want to practice in the Supreme Court, advocate on record is sort of, in a sense, necessary. Otherwise, you'll have to rely on, AORs and get signatures, get filings done, then rely on, reverting to you that, okay, this has been served on us. For as small as an adjournment letter, you'll have to, go through an AOR. So it is advisable that you become an advocate on record yourself.
And you were All India rank 2 in 2020 when you took the exam. Were you expecting that you will get such a good rank?
And see, I was sure that I'll clear the exam as
Okay.
soon as, but I wasn't sure that I'll get rank two. That is something which, which happens with God's grace. That is not something which anybody can predict. And that is not something which, see, because, see, at the end of the day, all my batchmates, course mates, in a sense, that we cleared the AoR exam in 2020, we are all equal. Nobody is more equal than other equals. It's just because of this rank, I got a lot of recognition. And, that's all. Yeah, matlab, nobody can actually, speculate that you'll get a rank. So it's all God's grace. I worked hard, I prepared hard, and I was very sure that I'll clear the exam. But for rank, I would say that that is God's grace.
And when did you start preparing for the exam?
See, I wrote the exam in June 2019.
Okay.
So I started preparing. See, I bought the study material and, rules and etc. in January. But I started, thoroughly preparing only in first week of April. So I think at least 2 months, 2 months of complete devotion. And because I did not take any dates in April and May, May is when the Supreme Court closes, mid of May. But the trial courts and the High Court, they are open in Delhi. So I did not take any date in April and May. And because I wanted to completely devote myself to the exam. So I started thoroughly in April first week.
Okay. And does any coaching or is there any exam guide that helps in the
Hmm.
exam?
See, there is no coaching which is required. This is more about self-study because we write this exam when you're 5 years into the practice. So you already know a lot of things. You already have appeared before chamber judge. You know what are the powers of a chamber judge, what are the powers of a registrar court. You already know, basics. So that is that ways, you don't have to mug up a lot of things, but still you have to, because a lot of provisions are actually nowhere in practice, but they're in the rule book, sort of. So I would say that 5 years is a very long tenure. So you are in a sense mentally prepared to write the exam. So I think, yeah.
Okay, and it is seen mostly that law students, after they have graduated, they have corporate law firm jobs or jobs in PSUs or even, preparing for lower judiciary. Did you also have such goals before going for the AOR exam?
See, I worked on the principle of exclusion. I
Hmm.
ticked off what I don't want in life. I ticked off that I can't be, in a corporate job because I want to be my own master. If I want to leave, I'll write an email to myself and take a leave. I can't write emails to somebody and, seek leaves is one. So corporate jobs I ticked off, excluded. Then, PSUs and see, I don't call it lower judiciary. No judiciary is lower as such. But judicial services, again, is, see, because you have to have that magisterial competence. See, if you want to be a lawyer, and there is something which is known as a judgivitis. If you have judgivitis and you want to become a judge, then you lose the charm of a lawyer. See, a lawyer is supposed to be, extraordinary in a sense that, there has to be a charm to, capture judge's attention and, get a favorable order, by gathering that attention in court. So I thought that I should do this rather than, because I think that magisterial competence, I was too young when I started this. I was 22 when I graduated. So I think at 22, I wrote the exam. Interestingly, I cleared it also, but I never went to the orientation because,
You wrote
because
the
I thought
exam
this
for
is,
judicial services, you cleared the exam.
yes, yes, I cleared the Rajasthan Judicial Service examination in 2013, but I
Wow.
never went to the orientation because I thought, कि this is, if I can clear this without any preparation, then this is not meant for me. So then I thought, I have to do something better. And then once you start living in Delhi, you can't go back to, some small town in Rajasthan. So that is when I decided that I'll give it a shot. And see, interestingly, I don't come from a dynasty, a judicial dynasty, or from a very privileged background. I come from a very humble background. My parents still live in, there's this small town in Rajasthan called Alwar. So my schooling till 12th was there. It is then when I went to NLU Lucknow in 2008 to 2013. I was there. So this was a very big leap of faith for me also and for my family. But my family was very supportive. They said, "You do whatever you want to do. We
Yeah.
have trust in you." And I also was confident that I'll, sail the ship through. So I decided, why not? So, so all these things are okay. See, corporate jobs I ticked off. This is something which I can't do. Judiciary I tried, but then that was not something which, I would have done eventually also.
Hmm.
So that is when I started. I thought I would rather, try and persuade judges rather than become a judge myself. At that age,
During the
I
exam, you realize you do not have what you say, judgevitis.
judgeitis. See, judgeitis is when you decide you want to become a judge and then you lose the charm of a lawyer. That charm should not go. And I was too young at that age also, so I wanted that charm, to persuade a judge, get a favorable order. I don't know how much I've succeeded, but yeah, I wanted to go through that phase, that struggle phase, and asking for work, doing work for free, and then start charging that now I can charge you right. So that journey is very, very important to train you to become an all-rounder as a lawyer should be.
That's
Yes.
amazing. Uh, as they say that AORs form the elite club of the Supreme Court lawyers. How true is this statement according to you?
I don't think there is any elite club as such. There's not a gymkhana club where where members are appointing members. So there is no club as such. We have a small association, but there is I don't think there is any sense of eliteness as such in becoming an advocate on record. It's rather a duty. It's rather a pious responsibility that you have towards the court as an officer of the court, because you are responsible for filing affidavits, for everything. You are responsible, and this is the highest court of the country you are practicing in. So the degree of responsibility is also exponentially very high. So I don't think there is any elite club. And we are also just lawyers. Yeah, we also go to all other courts. It's just that for filing a matter in the Supreme Court, you get an added advantage. That's all.
Who would you like to credit for your success? Who was your guiding force in academics as well as in terms of motivation?
See, success, I don't know how successful, because it's all comparative in nature.
Hmm.
But for whatever I am today, I would, give special credits to Justice Korean Joseph, because it is from him that I learned how to be, see, he's an exceptional human being, Justice Korean Joseph. So 1 year with him, I was, that was perhaps one of the best periods of my life. And there's so much to learn from him, not only law, apart from law also, there is so much to learn from him. And I recollect, and then I was a law clerk in 2013 to 2014. So, and he was such a pious man. Every day he'll go and pray. And he never used to pray for himself or his family. He used to pray for others. Every day he used to go to church. And he had this back pain when I was there. Even in that back pain, he used to go and stand for 2-3 hours in the church. And after that, he used to, do court proceedings. And there was this constitution bench matter of Manoj Narula versus Union of India, which was running then. And in immense back pain, he conducted the hearings, because if he would have said that I want a sick leave, then that bench had to be broken. There's a constitution bench, and having a constitution bench created in the first instance in the Supreme Court is also very difficult. So that was the level of commitment he had towards his duty as a Supreme Court judge. Then I was with Mr. Ranjit Kumar, and he's again an exceptional human being. He's so disciplined. There is, I see, as lawyers, law eventually you'll learn. That is why it is called a practice of law. But what you learn from your seniors is compassion. Like, for example, this is Corinne Joseph, passion and discipline, like, something which I learned from Mr. Ranjit Kumar. And then, of course, a lot of people in this journey who have, supported me. And uh, Mr. Ardendu Maulik Kumar Prasad, I used to, operate from his office only, and his wife Taruna ma'am used to sign, wakalatnamas for me, when I was not in the UA, and they never charged a penny from me because I was operating from their office. So that is also, as junior members of the bar, this is again a very big push. And then, Mr. Justice Anil Kumar Uppan, he is now a judge in the Rajasthan High Court. He used to, send me briefs from there. and he had given me a complete free hand that you do whatever you do and don't think about the outcome and you just fight it out. So and this was the encouragement which he gave me, and which really pushed me in the whatever, I don't call it, again, because success is comparative in nature. Whatever little I have done, whatever little output I can have given back to the society.
That's wonderful. You mentioned that a candidate who's appearing for the AOR exam has to have practice and some training experience. What should one bear in mind while choosing a particular field of practice and trying, which helps in preparing for the exams?
See, for first 5 6 years, lawyers are beggars, and beggars can't be choosers. So in first 5 6 years, I would rather say to the contrary, that you should not make yourself rigid and look for a particular field of law. You should keep yourself flexible and accept whatever comes. It is then when you train yourself. See, you can't in first 3 4 5 years of practice, you can't say that I want to practice only criminal law, because maybe after 7 8 years putting criminal law, cases don't come to you, and
Right.
only civil cases are coming to you. What will you do then? So you have to have a very wide exposure of miscellaneous cases of across all trial courts, all tribunals, all authorities, and high courts, Supreme Court, everywhere, wherever you get a chance, you should go. And don't. My suggestion would be to not make yourself, rigid enough that this is, a particular field. You may have an interest in a particular field of law. You may have an interest in criminal law, but don't, shrug off other fields of law because you want to practice only in criminal law later on. That will come eventually. And also, see, as you have to have a very good command on the procedural law. So both CPC, CRPC, you should be very thorough with as to what happens, what is the pecuniary jurisdiction, how it happens, where do you file an application, where do you file a petition, etc. And to be a good lawyer, you have to be a very good munshi. So you have to, write from, because initially you won't have a munshi. So right from making a file, making a brief, getting it photocopied, making a paper book, getting it filed, filing process fees, etc., etc., you should all do it at least for a good period of time in different courts yourself before you engage a clerk, or when you shoot off your solo practice or whatever you do. So for 5 6 years you should not be rigid. This is what my suggestion would be. Do whatever comes under the sun, and see, a good batsman bats on all pitches, because when you bat on all pitches, when the ball is going to come slow, and when the pitch is spinning, so you don't get out. You become Rahul Dravid, as the wall, and you keep bowling balls to the wall. The wall is standing. Yes.
That's amazing. Recently, in fact, as recent as yesterday, a very famous magazine has been critiqued by the SCAOR Association for its quest to rate the AORs in its top 25 list. What is your
Hmm.
opinion about it?
This is all sponsored. All these exams are sponsored. How do you judge what is the criteria of selecting top 25 advocate on records? This is all sponsored, because you have to pay some amount. All these emails came to all advocate on records. These emails came to me also. You have to pay some 25 30,000 and nominate yourself, and if you pay something more, you'll get an award. So so this is all business. So you want to get yourself highlighted as, okay, I'm the top 25 advocate on records in the country, and so you pay. And if you don't want that, don't pay. Be happy with whatever practice you have. It is
Like
not
an
going to affect anything.
advertisement,
It is not an achievement as such. If you're paying for it, what is the achievement?
right? So, lastly, this is the last question. What is your advice to young lawyers that plan on taking the AOR examination?
See, be very thorough with the commencement and completion certificates. Don't miss on dates, and start with seeing question papers of past 10 years, so that you get a fair idea as to that they ask in question papers. What is the pattern which is being followed, and keep going through the constitution, keep going through statute books. That is anyway going to enhance your knowledge. And then attend court proceedings as much as you can, because now there are virtual links also available. So take virtual links from whosoever you can borrow them from, and watch proceedings, because you'll get a fair idea as to what actually transpires in the Supreme Court. And not only longer hearings like before, reference benches or constitution benches. See also what happens on a miscellaneous day, because on miscellaneous days also you got to learn a lot. So watch proceedings, keep on reading, keep yourself updated, be very thorough with whatever concepts of law you learn, and be very thorough with the dates of commencement and completion. So don't be late on that, don't miss out a chance, because then you lose an year. So yes, that is something which would be my advice.
Thank you so much. This was a very insightful session. We got to know a lot about things that people already don't know. Generally, lawyers are not aware of. Thank you so much for joining us today.
Thank you, pleasure is mine, Ananya.
And with that, I, Ananya Singh, bid you all goodbye. Thank you for watching Verdictum.